Hello, my name is Andrew Kinney. I'm an attorney with Hoglund Law Offices based out of New Brighton, Minnesota. I've been doing Social Security disability work for over 30 years. Today I'm going to do a series of videos on what my clients ask me. So I have the top 5 questions my clients ask me about Social Security disability and SSI benefits. The first question my clients ask me is, what are the appeal steps? So we have Social Security disability and SSI. There are different qualifications for each. One is based on your work history. The other is based on your financial qualifications. But once you apply for benefits, the application level can take sometimes 6 months or more. You need to apply either by going online, or you could try to go to a local Social Security office. I'd advise going online if you can. But once an application is in, you're asking for Social Security to consider paying you benefits because you're unable to work for medical reasons. The application level is the first level. The second level, if you are denied at the application, is called the reconsideration. You have to appeal within 60 days of the initial determination, the date on the letter. Look for that because you'll get mailed letters for the response. The next level is called the reconsideration. That level, again, can take sometimes 6 months or more. That decision is to review the decision before and perhaps account for any new changes in your medical problems. If the reconsideration level is denied, then you need to request a hearing. The hearing request process gets you out of the lower level and into the Social Security hearing level. The first 2 levels are a state agency, and each state has doctors that they use through the Disability Determination Service to make decisions about your ability to work without talking with you. The hearing level, once the hearing happens, it varies widely how fast it takes to get to a hearing, but that's where you speak with a federal administrative law judge about why you're unable to work and what medical problems you have. If at the hearing there's a denial letter, you have then 2 months to request a review by the appeals council if you wish to appeal that. That is in writing, and that is actually a little more drawn out for the response. It's usually between 6 months to a year to have a response for that. Those are the levels, administrative levels, for a Social Security disability claim. They need to go in that order. And at times, let's say the appeals council sends a case back to redo a hearing, a rehearing is what I would call it, then it can go backwards to the hearing, and then there's another chance, if you get denied again at the hearing level, to request appeals council to review your file. Those are the steps in a Social Security disability and SSI claim. The second question people ask me a lot is, why are people denied so much at the application and reconsideration levels? Now, there are different numbers each year, but the general rule of thumb is probably a third of people may be approved at the application level when they're applying for Social Security disability or SSI. And then at the reconsideration level, about 1 out of 10 people may be approved then. And then at the hearing level, when you shift to that, the numbers improve vastly. My last count, it may be a little under 50% of people that request a hearing and go to their hearing may have a chance for an approval. Every case is, of course, different. Why the first 2 levels deny so many, if in essence they're undone almost half the time, could be looked at as a question of quality control. The first 2 levels are made by, decisions are made by state agency doctors. The things that they typically miss are things that would cause you in a full-time job to miss perhaps 2 or more days a month. So absences, that's a vocational question. Things that can cause absences are mental health, migraines, seizures, things like that. So expect to go to the hearing level if you have those issues. Another situation that the state agency may miss is if it's pain that is an issue. Pain is hard to quantify. I would advise, if you have issues, for instance, with low back pain, to make sure to treat for that problem and have imaging as needed so doctors know what's wrong. But in any event, the first two levels may not account as much for pain as you would wish. And in the first two levels, you're filling out a form about your functioning. It's called the activities of daily living. Make sure to answer simply and directly, but get to the point with what you really can and can't do. If you do not fill that out, that will be a denial generally at the application and reconsideration level. So you don't want to spin wheels there. The other reason that application and reconsideration levels deny so many, and those are overturned, is a little more cynical, but I see a pattern in 30 years of people who are getting close to the ages of age 50 or the age 55. Legal standards at age 50 and 55 change in your favor. I typically see someone that's trying to get benefits, and when they get near an age like age 50 and 55, their physical restrictions are not paid attention to as they should. So in an ideal world, the first two decisions would be made blind to age, but that is not the case that I see in my experience. In any event, those are some thoughts as to why people are denied a lot at the application and reconsideration levels. And the way I look at it, I've spent my career at the level after that undoing those decisions. And at times they're correct, of course. The main idea to keep in mind when you are applying or you have a case pending for Social Security disability is if you think you can find a job and your doctor thinks you can do it, it's probably better to try to do it, because Social Security disability is, if anything else, a long process. The other idea here is that whatever medical issues you have, make sure to treat for them the best you can. If you stop treating for one problem to treat for another, which can happen, then evidence does not exist when your case is being reviewed. And certainly keep treating while your case is pending, because the reconsideration level is looking for new evidence. Okay. But anyway, that is the second question that people most often ask me. The third question my clients ask me about is what is different about age 50 and 55, and do I need to be that old to be approved? Well, the short answer for that second question, I'll take that first, is no, you do not need to be 50 or older to be approved for Social Security benefits. You can be approved if you're unable to work any full-time job at under 50 because of medical reasons. Okay. The reason that age 50 and 55 comes up is there are medical vocational guidelines, or as the attorneys in our area call grids. When someone hits age 50 or in turn age 55, the legal standard changes in your favor. If the person's under 50, the question for Social Security is what are the problems that you're dealing with, and what are the limitations from those problems? And then finally, if you're under 50, can you either do your past kind of work or any other work? Okay. When you hit age 50, Social Security only looks at your past kind of work. So if you think about it, your past work is all that's at issue when you're 50 or older. If a person works construction, for example, and they have back problems, you're more likely to be approved when Social Security is only looking at your ability to do your past work, lifting and being on your feet and things like that. That is answering the question about do I need to be 50 or older to be approved. So please apply if at any age you're unable to work, what benefits you may be eligible for, SSI or disability insurance benefits based on your work history and your financial needs. But hopefully you can find a job that you can do. You can apply. My rough rule of thumb is if you are able to work, but you can only make about $1,500 gross a month because of your medical problems, it would be good at that juncture to consider Social Security disability. Okay. The fourth question that I'm asked about is how do I prepare for a Social Security hearing? I believe I may have done roughly 10,000 or more hearings at this juncture. It's a natural question. It's a good question. First, if you're seeing this video early on or even haven't applied for Social Security disability or SSI, that can be helpful. I recommend that people treat for their medical issues. It sounds common sense, but sometimes people get tired, let's say with migraines, and no one can help with the migraine frequency, so they stop treating with a specialist. If you stop treating, Social Security might assume that you're better. If you stop treating for a low back problem, they might assume you're better or don't have one. Or if there's a chronic problem from years ago, let's say a knee from high school, and it's getting worse now, it's important that doctors understand what's wrong and you ask about that. Perhaps get imaging, such as an X-ray or an MRI is needed. It is important to have ongoing regular treatment for medical issues. The first reason is you may get better. And of course, that's the goal. If you can get better while a Social Security claim is pending, and let's say that you haven't even been out of work a year, maybe you don't keep your Social Security claim going, because that's the standard. You have to be unable to work for a year or more based on your medical conditions. So with that, preparing for the hearing means to keep treating. Now, let's say that your hearing is scheduled. At that point, a way to prepare for a hearing, the way I look at it, is consider how your life is different since you've been unable to work. Work around, so to speak, at home. You're able to do the same chores you used to do. You're able to pursue the same hobbies you used to pursue. Um, uh, think of things that may have gradually occurred where you stop doing some things. And for instance, with mental health, if you used to read and don't like reading or can't read, things like that. It's good to think about the before and after. That can be helpful. And examples are helpful in your day-to-day life. That's what hearings are about, is talking about your day-to-day life. Medical records talk about how you're doing and the medical conditions, but generally it's the hearing where you're talking about what your day-to-day life is like and how you're limited, either physically, emotionally, or both, from your medical problems. So in terms of preparing for a hearing, I tell my clients, certainly don't write anything down. You don't need to do that. We talk through before the hearing what to expect in the hearing. I'll get to that in a little bit. But we also talk about being yourself, making sure to have an idea about how bad issues are. For instance, how long can you stand in minutes generally before you need to sit down? Or how long can you be around other people? Or can you be around other people at all? What symptoms do you have? Also, I find myself asking clients in preparation for a hearing, if you have panic attacks, how often? It really helps to get a sense of that. If you don't think about it, it's good before a hearing to think about how often you have issues, seizures are another example, because how often a problem happens, like panic attacks or seizures or different issues like that, is relevant. If someone had one panic attack a year, that's much different than one panic attack a day, for example. So think about how frequently you have problems. MS flares would be another, or else your baseline issues with MS. Every medical issue or issues, they all have their different dynamics. But consider those sorts of things as you prepare for a hearing. You can and have a right to get an attorney for your hearing, even if it's scheduled and you don't have one. You can contact your hearing office and mention that you're trying to get an attorney. And if you are at a hearing and are unrepresented, you can postpone the hearing to be able to get a representative of your choice. That's your right. So don't despair. So that's what I would want to tell you about in terms of preparing for your hearing. The final question I have answered is what happens in a hearing. That's what I spend most days doing, is being in hearings. They generally last about 45 minutes. And in these hearings, judges verify who you are, and it's either a phone format, video format, occasionally in person, but the phone or video format works fine. The judge will verify after your identity, verify you're alone in your room, verify that you swear to tell the truth. There's also a job expert that's in these hearings that will do the same. And then at that point, the judges usually ask you about your past work in the last 5 years, or at least from 2020 forward at most. And there are exceptions, of course. But in other words, the judges ask about past work that you did. Did you sit or stand doing it? How much did you lift doing it? What was your job? Then, after discussing past work for a little bit, the judges get into the medical questions. Medical questions that you'll be asked are along the line of, hey, tell me, do you have back problems? The judge will have read the file. It makes sense to ask, how do your back problems limit you? Or perhaps on a scale of 1 to 10, 10 being the worst kind of pain, how bad is your back pain? But typical questions start with that. I may follow up with, do you have pain in your back that radiates down one or both legs, in that example? Or if someone has seizures, do you know when seizures are coming on? How long do your seizures last, or do other people tell you how long they last? And then finally, how do you feel after your seizures? How often a person has seizures is definitely relevant for the hearing itself, but before and after is important too. Judges do ask, and it makes sense that they would, if you're taking your medications as your doctor's request. For instance, if you have diabetes and neuropathy, are you making sure your diet is in line with diabetes? Are you making sure to see your doctor as needed? Are you taking your insulin as needed? And even if someone has an insulin pump, the question still arises, does your blood sugar rise high or go low on a typical week? And can you tell? Do you feel faint? Do you have to stop what you're doing until that gets adjusted? These are medical issues that would limit your ability to work any full-time job, sitting or standing, if you would need to take extra breaks beyond the normal breaks in an 8-hour day. In these hearings, the judge and your attorney would ask you questions, and then the judge will shift usually to a vocational expert. Once in a great while, there's a medical expert, but in any event, with a vocational expert, the judge and your attorney or representative will pose hypothetical questions about different limitations and then say, given these 10 limitations, can this person return to their past kind of work or other work? And you'll hear a series of different questions that either do or do not allow for full-time work. And it is about full-time work, not part-time work. That's what the hearing is about. Some judges ask if there's anything you wish to add at the end of the hearing. The important thing is that at a hearing, it doesn't cover everything in detail. The medical records are available to the judge, but what you need to do is make sure that you're touching on the main things that limit you and affect your ability to work. There are some conditions that you may have, like high blood pressure, but if you have no symptoms from that, for example, it is a medical condition, but it doesn't limit you, and it would not, in theory, affect your ability to work. But I'm being general here. Hopefully, those 5 different questions and answers help you with your situation. And my goal in these videos was to help reduce some stress about the hearing itself. I tend to look at getting to the hearing as a good thing, because you can talk to someone about how you feel, and you can talk about how your day-to-day is limited and how your life has changed. That is a good thing, because you are not being heard at the first 2 levels. You're filling out forms and waiting for people to decide what you can do without talking with you. So good luck with the Social Security disability process. Again, this is Attorney Andrew Kinney from Hoglund Law Offices. Hopefully you have a good day. Take care.